So the odds of jury nullification happening and of the prosecution being denied a conviction are, even with 5% of people aware that they have the right to nullify the law, the odds of a nullification are 46%, and the prosecution's odds of a conviction are only 54%. So no prosecution will enter court with those odds of a conviction. They will just dismiss the case. But they don't want you to think they're going to dismiss the case, so they'll threaten you with 10 years in prison. They'll threaten you with something crazy that you can't risk. You can't take the risk that that will happen to you. And so every libertarian candidate should campaign on a platform where they explain this to the people in their district, and they campaign against cruel and unusual punishment. And they campaign on a pro-civil disobedience, pro-jury nullification platform, because that's what we're supposed to have already. And the average voter thinks that's what we do have. The average voter thinks that's the system that is in place now. They're unaware that the system has been corrupted. So that's the core explanation, and you can figure out the prosecution's odds of a conviction fairly easily for yourself. And most people have an idea of the kind of people who live around them or who live inside of a district. So let's say that you're from an all-Republican area in Texas, and you're charged with a gun offense, a victimless, non-crime, non-criminal gun offense that shouldn't be considered an offense at all, because there's no injury and no intent to injure another living human being. The prosecution is going to claim that you injured society by not following laws that are unconstitutional anyway. So you didn't injure anybody, you didn't injure society. Their entire case against you is a fabrication comprised of, 100 or so years of corrupted law, because even if legislators had nothing to do, if they got elected as legislators, they couldn't just sit around all day, because the general public would say, hey, these guys are just sitting around all day, let's abolish the legislature. Or let's reduce the number of days that the legislature is meeting. That's a very sensible thing to do, in my opinion, if you can get it done. But so rather than do that, rather than just admit that they have nothing to do and all the laws are already on the books that are necessary, they sit around making laws about everything and piling those laws on top of the Constitution, even though those laws are mostly unconstitutional. Now, those of you who had a halfway decent history class at any point in your lives, you probably remember that the first Supreme Court case, first big controversy, was Marbury versus Madison. And the Marbury versus Madison case stated that any law that was repugnant to the Constitution is null and void from its inception and need not be obeyed. So you don't have to obey unconstitutional laws, and you should rely on the jury to vote not guilty or hang the jury. You're only relying on 1 out of 12 to hang the jury. And that's true, that if the jury is hanged, or if the jury is hung, then that means that the prosecutor can try you again. But if the jury is hung in one case, they usually won't try it again. Usually they'll just dismiss the case and just let you go free, because you could bring up to the next jury that the previous jury was hung. And it's true that your bar licensed attorney wouldn't do that, because he's afraid of being disbarred. He has to practice law in that same court in front of that same judge, unless he's going to be a traveling bar licensed attorney who's licensed in multiple states and not come before the same judge on a regular basis. So that's how they systematically render defense attorneys impotent to challenge the legitimacy of the law. They assume the law is legitimate, and the judge will threaten any defense attorney who challenges the legitimacy of the law and encourages the jury to nullify. They'll threaten that lawyer with disbarment, because they've licensed the practice of law. Well, anything where you're operating only by a state permission, a license, a permission from the state, or a permit from the state to practice your profession, that profession is under state control. So the practice of justice in every state is under state control. The judge represents the state. He's a state employee. He's paid by the county. So is the prosecutor. The prosecutor is also paid by the county. So the licensing brings the practice of law, even defense law, under the power of the existing state. It creates a legal conflict of interest where, to protect his own ability to practice the law, the bar license defense attorney realizes he can't be stripped of his license by the state. And the judge, unfortunately, and prosecutor have gotten to the point where they can strip someone of their license, they can put them before a panel of other bar licensed attorneys. They're all corrupted, they're all bar licensed, and they'll vote to strip that person of their license. And so that's something that every libertarian office holder can campaign against, because that is a change that would need to be made at the system level, at the political level, that would have to be made. So even if you're arguing that there should be no bar licensing, and even if you're a pro se defendant who's going to represent himself and argue directly to the jury over the protestations of the judge, even if you're in that situation, you don't have the ability to repeal bar licensing. Only a politician would have that ability, or only a citizen-sponsored initiative or ballot measure or referenda like the ones that legalized marijuana in several states in the last 3 election cycles. Only a citizen-sponsored initiative would have the ability to abolish bar licensing. And only Wisconsin was the only state where you did not need to be a bar licensed attorney to practice law.